Hi friends, myself Advocate Shahed Ali Ansari, a practicing lawyer at High Court Bombay. Today I would like to have discussion with you regarding one of the important and pivotal section of the Transfer of Property Act, section 13. Section 13 of the said act speaks that transfer of property for the benefit of unborn person. It means under this law, under this section, even the property can be transferred by the transferor to an unborn person, a person who has not born or who is not even in the womb of the mother, or the person has not come into existence, or who has not got birth. Even to such a person, the property can be transferred from the transferor. Normally, what rule of the law says, principle of the law says that the transfer of property is an act between two or more living persons. Therefore, at least there has to be two living persons so that the property can be transferred from one person to another person. This is called inter vivos. Transfer inter vivos. It means property must be transferred from one living person to another living persons. However, section 13 of the said act, that is Transfer of Property Act, is an exception to the rule which says that even the property can be transferred by the owner, that is transferor, for the benefit of unborn persons. But certain conditions need to be satisfied so that the transactions under section 13 of the transfer of property could be validated. What are the conditions required for that? Number one, the transferor must create a prior interest, means a person who should hold the property like a trustee, because the property cannot be kept in abeyance, because as on today the unborn person is not in existence. Therefore someone has to be there, one person has to be there who should hold the property, who should enjoy the property, who should be like a trustee of the property, who should take care of the property till the unborn persons come into existence. That is, unless and until the unborn person gets birth, till that time the prior interest, that is called mediator, has to take possession and enjoyment of the property. Therefore prior interest has to be created by the transferor, and such a mediator or prior interest will hold the property, will enjoy the property, but he will not have any sort of title interest in respect of the property. Only life interest is created in his favor. He can only enjoy the property, but he cannot become owner of the property. He does not get absolute right in respect of the property. Only he is like a trustee. Therefore prior interest has to be created, means mediator has to be created under a document. Thereafter, the second condition is that the interest so created for the benefit of unborn person, the whole remaining interest in the property must be transferred to the unborn person. It means the absolute interest in the property must be transferred to the unborn person. For example, A is a person who wished to transfer the property to his grandson C, and Mr. B is his son. So the grandson C has not born yet. Therefore Mr. A has created a document and he transferred the property to B under this section 13, so that the property could be transferred to unborn person, that is his son, who has to born, who is yet to be born. Therefore the whole remaining interest in respect of the property, means absolute interest in the property, will go to the unborn person, if A says that I am transferring this property to C, unborn person, and after the death of C, his younger brother, who is also unborn, will get the property, or thereafter, whose younger brother X will also get the property, then such such a transaction is invalid under section 13 of the Transfer Property Act, because the law of section 13 says that the whole remaining interest in the property must be transferred to the unborn person. Therefore, there shouldn't be the absolute right in respect of the property must be transferred. There shouldn't be any sort of condition, or the transfer must not be conditional one. Therefore, the transaction would be like this: A is transferring the property to C, unborn person, and he is creating the prior interest in, he is making the prior interest to B, his son, and he is transferring the property, entire property, absolute property, creating the absolute right in favor of the C, unborn person only. Therefore, this transaction will be valid. Now, it means absolute interest must go in respect of the property in favor of the unborn person. Now, what are the possibilities and probabilities? See, in that case, the property cannot be kept in abeyance. Therefore, A must transfer the property to B, and B should enjoy the possessory right in respect of the property. He cannot claim the title in respect of the property because he is like a trustee. Hence, if prior interest dies before the unborn person comes into picture, that before the birth of the unborn person, if prior interest dies, in that case the property will go back to the owner of the property, that is transferor. And in case if the transferor also died, then the property will go to the legal heirs of the A. Therefore, the unborn person must come into existence before the death of the prior interest. Otherwise, the property will be reverted back and the transaction could not be fulfilled and cannot be executed. Therefore, this law says that the unborn person must come into existence before the death of the prior interest. Otherwise, the transaction will be frustrated. What happens if twins born? Even in that case, both will get the right in respect of the property. And as on the date of transfer by A, the C should not be in the womb of the mother, because child in the womb is also considered to be a child alive. Therefore, this is a very tedious section. People get some difficulties in understanding of the same. I have tried my level best to express it and to convey the message to my audience. Thanks for hearing to me. Thank you.